Windrush Scandal. And as many of you here have experienced firsthand, the process of seeking justice through this scheme is anything but straightforward. It's time-consuming, complex, profoundly burdensome, and often traumatic. Our report today is really a deep dive into the difference that legal advice can make, and through speaking to claimants who have experienced of applying through the scheme, both with and without a lawyer, really gets to the heart of exactly what difference proper legal representation makes for those who are going through the compensation scheme itself. This report has one recommendation. I've just got to underline, this is really rare. Justice normally has at least 10. We have one recommendation. It's to provide funded legal assistance to compensation scheme claimants, and we very much urge the Home Office to take it up. Before I hand over to our host, Chair of the Justice Select Committee, Andy Slaughter, I want to say a big thank you to the four co-authors, Jo Wilding at the University of Sussex and Decca, for all their work to support this report. In particular, Pro Bono Counsel Marianne Edge, wherever she is, who has been quite simply tremendous, working tirelessly to coordinate all the interviews, oversee the drafting and the design of the report today. Also want to say a very quick thank you to the brilliant Justice team, particularly our Legal Director, Stephanie Needleman, who played a really big role in this, and Vidya and her team, and Jess and Ben for their brilliant support for the event and sharing the report as far and wide as possible. We'd hoped that Belle Rivero Addy was going to be joining us to say a few words, but unfortunately not able to join us today. But I'm really pleased to say that Baroness Benjamin has agreed to say a few words before she gets to go and do other important things. Okay, handing over. Thank you very much.
Thank you very much. I'm absolutely delighted to be in this room today. We see so many people who come out to celebrate this report, this important report. And from the time I walked into this room, I've met so many people who claim to be my play school babies. Who I took through the round window, the square window, the arch window, and now the neo-Gothic window. Windrush means so much to me. I am one of the Windrush Generation. I am a 76-year-old woman, so I'm very much part of that generation. I came here when I was 10 years old. I came from Trinidad to London. And I came here expecting to be greeted with open arms. Because back in Trinidad, as I said, I was born in 1949, so the schools at that time in Trinidad learned about Britain. Britain was the motherland. We learned about British heroes, British history, British poets, nothing about our African heritage. We were encouraged to come here after the Second World War. We were told we were needed to come and rebuild Britain, and we came gladly to come and help the motherland to survive once again, to make this great country what it was. And I could not believe the rejection that I had to face. Each day as I went to school, I was spat upon. I was told, go back to where you've come from. You're not needed here. And that wasn't just me. It was my other 5 brothers and sisters, and all the various people from all over the islands, what they had to face on a daily basis. Rejection, humiliation. But we were resilient, we were determined, we persevered, because we thought we were helping the motherland. And we've given our hearts and soul to this country. So when the Windrush Scandal erupted, I like to call it the Home Office Scandal. It's not a Windrush Scandal. We don't want to be known. The Windrush name mustn't be tarnished with the scandal that the Home Office have caused. When that happened, many hearts broke. We couldn't believe what was happening. The people who had toiled to make this country great. The people who had given their hearts and souls. The people who felt they had a duty. This is how they were being treated. And I've stood up here in Parliament many times, calling on the government to have what I call a Windrush Day. With Sam King, back in the 80s and the 90s, was saying we needed a Windrush Day. I was told, no, Lady Benjamin, we've got Black History, but we don't need a Windrush Day. But it was the scandal that made a difference. I believe our out of bad always comes good. Because I got a call from number 10 to say, Lady Benjamin, we are going to have a Windrush Day. But even more so, we want to have a national Windrush monument to celebrate the contribution Caribbean people have made. And we want you to be in charge of the National Windrush Monument Commemoration Committee. Here's £1 million. Now, £1 million is nothing for a monument, but I came under budget. It took 4 long years. It was a labour of love. I wasn't paid for it. I was doing it as a duty to the people who had suffered, the people who were going through that scandal. That was a representation of them being there, really seen. And many people who helped me, I came under budget for many people who helped me, are white people in this country. Because when they heard of the scandal, they thought of the injustice that needed to be right. Wrongs needed to be right. And they actually said, we're going to help you do this. And we put it up at Waterloo Station, where thousands and thousands of people had come through that station. Not to go just to Brixton, but to Birmingham, Bristol, Bradford, Leeds, Nottingham, Norwich, all over they went to try and help rebuild Britain. Even in the coal mines in Wales, they came. And yet, they had to go through this awful, awful scandal. I hope that some of you will go and pay homage, a pilgrimage, to see that monument at Waterloo Station, platform 19, where I came a few yards with my little grip. That monument, 60 years later, I was in charge of putting up that monument as a representation. But the job hasn't been done. The job hasn't been done because the scandal hasn't been solved. Victims are still seeking compensation, and time again, I'm challenging the ministers to say, why can't we have legal aid? Legal aid will solve the problem. Legal aid is what is needed, because so many solicitors are doing pro bono work, but there's only so much they can do. They've got to pay their bill, the electricity, they pay their staff, to pay pay their rent. So how can they all do pro bono? And I've had 2 meetings with the minister so far, and she said, Floella, we're looking at this. But I said, we've had all these millions of pounds put aside for compensation. Why can't we use some of that for legal aid? And she said, that's not how it works. It has to come from the Treasury. So I want all of you to write to the Treasury and say, why can't we have money for legal aid? Other scandals have got money. Why can't we have money? Sometimes they mention all the various scandals. We have the post office scandal, which is terrible. We have the blood, which is terrible. But they never mention the Windrush scandal, the Home Office scandal, in the same breath. I want them to start thinking of us. Start seeing us as people who need to have justice on their sides. We need to make sure that nothing is left undone. Out of bad always comes good, and I know it will come good eventually. There's supposed to be a Windrush commissioner who's going to be announced pretty soon to represent for Windrush Day as a representation of what the future holds. And I know the ministers, I said I've had 2 meetings with her, and she really wants to solve this issue. They've given 1.5 million to help, but that's not real legal aid. What's needed is more than that. We need people's stories to be heard. So each one of you have got to write letters to your MPs, write letters to the Prime Minister, time and time again. Make it a daily thing that comes up on your computer. Letter to the Prime Minister, letter to my MP, letter to the Minister, letters to anybody who you know will listen to you, because there's a real appetite for change, and we will not lie down and let them roll over us. We're going to make sure that this issue is solved. Not the Windrush scandal, but the Home Office scandal. They've got to take charge of making sure that we are listened to. So I want to thank you all for being here. People of all colours, people from all backgrounds are here today because you believe on what this report is saying. And it's not just the Windrush money that's going to solve it, it's the Treasury. The Treasury needs to hear our voices. So I'm hoping that you're going to go out and play your part. Not just by coming here and having the brochure and then thinking I've done my bit. No. I've written letters and letters and letters and stood up and time again. Never afraid to speak out. And I want you to be the same. Don't be afraid to speak out, because out of bad always comes good. Everything happens for a reason. And we're going through this because it's going to come good. Something's coming, something don't know what, don't know why. Maybe soon. Thank you all very much.
Difficult to follow that. I can't sing. And I'm so much further and educated me, not just through Facebook, but she was the chancellor of my old university, Exeter, but she just educated me more today, and she's a fantastic representative of this particular cause. My name is Annie Stewart. I guess I'm here because I'm the chair of the Justice Select Committee, but I'm also a London MP, and I myself have dealt with a number of Windrush cases over the last 10 years, as many MPs have. We are not ignorant of what the situation has been, the great injustice it has, with the lack of accountability and the lack of redress. And at the same time as identifying those injustices, we have also gone through, in the last 15 years, a collapse in legal aid. We've also gone through, because of the infamous LASPO Act that many people here will know about, the fact that it is impossible for many people in many walks of life to be able to get representation. And this report goes right to the heart of that and shows the difference that representation makes. There is, on Saturday evening, I went on the 8th anniversary of Grenfell, and I was on the silent walk. Today, there will be the launch of another national inquiry into sexual abuse in the Commons. But you can reel off now these huge injustices. The amount of time that all MPs who've had victims of contaminated blood scandal to get that inquiry. The fight to get the Nottingham attacks inquiry, and I have very similar cases to that amongst my own constituents. The post office inquiry. Something is deeply wrong in the way that the British state both has created these crises and then failed to expose them when they've been created. I hope that is changing. We will have the bill for law shortly. It's been delayed. I hope that will address not only that longest standing injustice, but also two other points. The first is, when you have an inquiry, when you know what's gone wrong, what happens to the recommendations? Do they just sit on the shelf? Do they get implemented? And that's why many MPs now support a national oversight mechanism to ensure that when there has been a regulatory inquiry, where you have got to the truth, that there is implementation. I'm shocked to find it will take another 4 years for the Grenfell recommendations to be implemented, but there is an undertaking to do that. So it's important to investigate, it's important to follow up on investigations, but to have the full facts and to have full redress, you have to have proper representation. It is totally unreasonable to expect people who themselves have suffered, who themselves have been victims of authority, to then on their own fight that battle, and often when they are caught. That's what I think this report is about today, and that's why I hope we are going to see, as a result of this and other initiatives, that there is an increase in legal aid to support people who have been the victims of injustice, that there is proper representation. I'd just like to pay tribute to justice, but most of all to the Windrush survivors, Home Office survivors in that way, who battled for so long for justice, and I hope that will come a step nearer after today. Thank you very much.
Well, welcome everybody. Thank you all for being here. My name is Tim Bowden. I'm a partner at the Decker law firm. We've been very proud to have had the opportunity to support this research. Not just me, but a team of between 20 and 30 associates, staff, all working hard to do the research, put together the report. All under the direction of the lady who sits next to me, Dr. Jo Wilding, who's the Associate Professor of Law at the University of Sussex, She has led this research and has brought the academic vigour to it, which you see in the report that's been published today. Helping us today, we also have to my left Letitia McIntosh and her husband Vanderbilt McIntosh. They are survivors of the Windrush Scandal. You'll be hearing from them later about their story, their experience, particularly with the Windrush compensation scheme, and how important legal representation was to them and their fight for compensation. To my right, similarly at the far end of the table, we have Marcel Carey, also a survivor of the scandal, who again very kindly, and so I should give thanks now to all of the people who have helped in the research, who have given up their time to be interviewed, sometimes going back over painful experiences to help contribute to this important piece of research. Letitia and Vanderbilt are two, and Marcel is another, and there are others I know in the audience, and my thanks goes out to you. And also Frank Kingarder, who is the director of the North Kensington Law Centre. He has been representing claimants to the Windrush compensation scheme for several years. He has extensive experience of the scheme, and he has also helped both identify suitable cases and to assist with the research, and he'll be helping us today as well. But if I now hand over to Joe, please, to take some. I'm going to grab that jug.
I just want to echo Tim's thanks to all of the Windrush survivors that took part in this research. We're so grateful. For me, it was such a privilege to be part of this research. And I also want to add massive thanks to, I can't see her, but Marion Edge. Because although it's Tim and me sitting up here and it's my name on the front of the report, Marion has been the absolute driving force behind this, from start to finish, bringing everyone in, getting everyone together, keeping everything on track. So thank you, Marion, very, very much. So this research came about because when Justice and DECA did their previous report on the Windrush compensation scheme, they became aware that there were people who were getting either a refusal of compensation altogether or a very low offer when they applied on their own. And then when they subsequently had a lawyer to help them with the first or second tier review, they were getting very substantially more compensation. And you'll see in the report how big some of those differences were. So the idea of the research was to evaluate with empirical evidence what actually lawyers were doing and what difference it made to have a lawyer. So the hypothesis was the lawyer will make a real difference and they will do something that the claimant couldn't do alone. But more than that, that actually it's impossible for these claims to be fairly decided without legal representation. Even what looked like the most clear-cut of cases on the face of it still benefited from having the lawyer involved. So the cases we were initially looking for were ones where someone had applied a loan, had received a low offer of compensation and had subsequently had a lawyer involved in their case. And we wanted to look through the files and see exactly what the lawyer had done that the person couldn't do themselves. So the full methodology is in the appendix to the report, but this had ethical approval from the University of Sussex. And essentially we had pairs of lawyers from DECA going through the case file, combing through according to a file review guide, and then the same pairs of lawyers interviewing the claimant, the Windrush claimant where possible, and their lawyer. And it soon became quite clear to us that there was a second subset, if you like, of claimants who simply could never have made a claim alone because of age, because of physical or mental health issues, because of dementia, because they were street homeless. So we decided we would include these in the study, and they came to be known as cohort 2. And so we wanted to also understand what it was that the lawyer had been able to do and whether there had been any prospect that the claimant could have done that by themselves. So we reviewed files for 17 people altogether. Now that might not sound huge, but it's broadly in line with what you'd have in a qualitative study where you want to go into real depth about what's happened. And what was really exciting about this for me as a researcher is that you never get to compare the same case with a lawyer and without a lawyer, where the decision maker's question is the same. You just don't get to do that. You can't do it in an asylum case because one's an application, one's an appeal, for example. So this was really sort of exciting as a piece of research as well, and I think shows more broadly what the lawyers do in cases where the law is complex and where people often can't do that legal representation by themselves. And I think what's really important about the research and what it really illustrates, as well as the huge differences in compensation, is that each one of these claimants only had a representative because of charity. Not because they had an automatic right to access to justice, but because somebody was doing a pro bono clinic or pro bono work from a city firm or a law centre doing this work pro bono. And often they only had a representative because of the geographical coincidence of living close to someone that was doing that or happening to be hospitalised in an area that had a relationship with a law centre. And it shouldn't be down to chance or down to charity in that way. I'll hand back to Tim now to introduce the key findings of the report.
Yes, so the recommendation of the report is that provision for paid for legal advice and representation needs to be provided for in relation to the Windrush compensation scheme. But what are the reasons behind that? What did we find? We found a series of things which support that conclusion. We found that lawyers in particular were important for, first, for enabling claimants to give their own evidence by compiling witness statements or accounts on their behalf. Second, for bringing expertise in gathering evidence, finding evidence that other people couldn't get hold of, for understanding that evidence, for interpreting that evidence. Third, for understanding and being able to put forward arguments about a person's eligibility for the scheme in the first place, especially when that concerned their immigration status. Fourth, to act as a protective buffer between the claimant and the Home Office, because a lot of potential claimants have already been traumatised by their experience and their treatment by the Home Office over the years. And engaging with the scheme presents effectively a choice of either experiencing further distress, dealing with an organisation they do not trust and have no reason to trust, or walking away without the compensation to which they're entitled. Fifth, to navigate a claim form which runs to 44 pages and the accompanying complex set of rules and guidance which goes alongside it. And sixth, to identify when the decisions that have been made under the scheme are inconsistent with the guidance and advise whether the level of compensation actually offered was appropriate or not, whether there were grounds to challenge, and enabling claimants to make an informed decision about whether they accept an award which might be fair, or whether they ought to pursue an appeal, delaying them receiving any compensation at all, but perhaps enabling them to obtain compensation which is fair. And also to identify public law errors in the approach of the Home Office and their decision making under the scheme. We also found that legal representation was necessary in order to effectively access expert evidence like medical reports, which claimants generally couldn't afford, nor did they have the expertise or the experience to find a relevant expert in order to prepare that report. But those reports are absolutely necessary under a scheme which is avowedly evidence-based, in inverted commas, to demonstrate the impact on life which the claimants have suffered. When it came to cohort 2, which Joe just described to you, the lawyer was needed for essentially everything, from getting the form completed, to all forms of evidence gathering, for putting together statements of the applicant, their friends, their family, even to helping set up a bank account so that the compensation could be received by a street homeless claimant, for example, or assisting with making a simple, straightforward will so that a claimant nearing the end of life could ensure that their claim or their compensation was passed on to their own choice of beneficiary. I'll go through those, and Joe will go through those in more detail. Firstly, witness statements. It is inevitable, we found, that claims under this scheme will lack documentary records. Sometimes that is because they've been lost over time, or because they're no longer available. But also because some of the relevant facts under this scheme are not amenable to being proved by documentary evidence. The claims are based on what happened to people, what they experienced in the terms of the scheme, the impact on life. So claims depend on a narrative. What happened, how the claimant's life was impacted, the effect on them, their living conditions, their job prospects, their family life, their relationships, their mental health, their physical health. And that all needs to be expressed in writing so that it can be considered under the scheme. Now, we might call these witness statements, but there's no necessary formality to that. There can be a narrative account written on the face of the form. And that could come from the claimants themselves, but also from people close to the claimant, statements from others. But how do you go about doing that? What is relevant or irrelevant for inclusion in that statement, in that account? What should be included? How detailed should it be? What should be explained? And what can be summarised? And how should it be set out? How do you make an involved life story coherent and understandable? What can the reader be expected to know for themselves, and what do they need to be told? Lawyers are ideally placed to consider what ought to be included in a witness's account, how it might best be organised, and set it out to make it understandable for the reader, for the caseworker making a decision. And remember, as many in the room will, that this is in many cases, the effects on the claimant have endured for decades. And it might be necessary for somebody to tell their whole life story. So when they arrived as a child, what their parents did, how and where they were schooled, where they grew up, their efforts to obtain work, to secure housing, whether they were able to travel, whether they were able to leave the country and return, the impact on their family life, and the impact on their own children as their children grew up and perhaps faced their own problems, proving their status. The efforts they made to resolve the situation, the impact on them varying as it does over time. And what about when their children grew up, faced their own challenges, and the impact on them as they grew older? Health deteriorated and more support was needed, and perhaps not able to access it. None of that is an easy thing to write in a coherent and understandable way, sufficiently explaining who all the people are in that story and their relevance, so parents, siblings, romantic partners, children, stepchildren, grandchildren, employers, friends, all the people who make up part of life and therefore see that impact on life. And of course, cross-referencing to the documents that are available. That is not easy. And we found that many claimants struggle to understand the type and quality of the evidence required, and their statements tended to omit key information, and importantly often fail to link their experiences with the inability to prove lawful status. And so their evidence tended to be very brief. Statements tended to be an average of 1.5 pages, we found. And therefore they were only referred to very briefly in the decision letters which were then generated by scheme caseworkers. And most were not offered an award. And caseworkers were making decisions based on information which wasn't sufficient and wasn't the best information that could have been provided to them. Accounts were long on emotion, short on factual detail. And this emphasised the difficulty in claimants putting forward their own case objectively when it was so personal to them. Many of the cases we studied were rejected because explicitly there was insufficient evidence prevented to demonstrate that hardships were caused by the inability to prove the status. After the lawyers became involved later on in the claim, the statements became longer, they became more detailed, they were rooted in factual events, and they explained the link between the inability to prove status and the loss and damage that had been caused. And that led to a noticeable difference in the decisions that were made, the way they were described, and they had to look at the facts far more closely. And remember, as Joe said, these are the same cases with the same facts. The only difference is that there's now a lawyer involved, and the difference is in the result. Letitia, could you tell us a little bit about how you found the process of making a witness statement and how you were able to get your claim across?
Okay. Thanks, first of all, for inviting us this afternoon. At the start, it was very overwhelming. Where do you begin? For my husband and myself, our story started in 1984, and we're now in 2021, because 2018 is when we got wind of the scandal and we applied for our citizenship and returning resident status and so forth. That was done in St. Lucia. But it was the compensation scheme was in 2021. And my husband and I, we sat down, and when we decided to apply, because at first I was very skeptical, knowing what I know. I had lived in the UK from a child of 8 years old, and he 5 years old, worked, I was in the British Army, and the questions that were asked, even in the application for citizenship, there was a back and forth. So I'm thinking, okay, compensation, people don't like to give away money, and it's not going to be easy. I'm listening to, we were doing some Zoom calls with the Home Office. They made it sound very easy. If you don't have, we know this is historical, you may not have the proper documentation, we're going to help you, we're going to assign you a caseworker, and everything is going to be okay, you don't have to worry. I believe them. Up to a day like today. What's the day? The 16th of June, 2025? I've never spoken to a caseworker. Every time I called the Home Office, no one was available. We have not been assigned one yet. So, submitted our application in 2021. We got a response in 2023, February of 2023, nil award. Vaughn and I we sat down because there's so much that goes on in an individual's life. We had 3 children, we lost our home here in England, we felt forced out of the UK. He's saying, he's the man, he have to go back to St. Lucia, that's where he was born, nobody cannot make him feel as if he's not a part of, because we grew up thinking that we were British. We were born in 1955, so that's telling you how old we are, 70, and we thought we were British because we were here from childhood. So this situation knocked us for 6, so to speak. How do you talk about not feeling wanted? How do you talk about feeling rejected? How do you talk about, how do you lose your citizenship? Basically, you lose who you are. So how do you put that down in an A4 piece of paper and be able to explain it? It was very difficult. So you do the quick thing. Okay, we applied for our passports to be renewed to prove that we were legal in the country because his job was changing. We put these basic things down. send it in, call in helpline, we've not heard anything. That is in 2022, 2023, beginning of 2023, we hadn't heard anything, and then you get a letter, an email stating nil award. So all the time, what happened was it brought back a lot of hurt, a lot of trauma. It brought back feelings that, because it wasn't only about us, it was about our children who were born British. And we took them to a country. I'm not from St. Lucia. St. Lucia speaks French. I only speak English, broken. And it was difficult having to learn a different language and a different culture. Then my children, thank God, did well at school and wanted to go to university. Coming back here, then it was problems with the university. They went to University of Manchester and the University of Salford. My daughter, after doing her A-levels there, she got refused for funding, and that was another. She appealed and she got refused, and they had stamped my husband and I just 6 months visitors visas when we came in. And this thing it tears at your soul. It tears at you mentally, because you want to know, who am I? Where do I belong? I'm speaking to you and I'm feeling it. You feel, how can people do this to you? And there's a brick wall. Because no one is answering you. I come in the country, immigration, speaking to immigration, saying, I lived there from 8 years old, I've done my children, raised my children, we were married here and everything. But there's records. But according to the Home Office, we only existed in 2018. The 14th of September 2018. They have no records for my husband and myself. HMRC has records for us. DWP have records for us. Ministry of Defense have records for me. I've got my veterans badge. Home Office don't have nothing. Nothing. Okay? They have nothing. So how do you talk to someone who doesn't know you at all, who is telling you that you don't have anything? How do you confront a system, an insidious system, because they make you believe they're going to help you, but they're helping you further in the pit that they've already put you in? And that's how I feel. Those of you that have experienced it, you know what I'm talking about. Okay? Now, that is how we were able to go through emotionally, and we're still dealing with it emotionally. It's not an easy thing. It tears at you. Honestly, you've asked that question, and I know you've got it, but making the witness statement, it took us back to so many different areas, impacting my parents, his parents, because they had children, our parents had children born in England. We were the ones who were born in the Caribbean, the two of us. But our siblings are born here, so they're okay. So once again, you feel rejection again. And because there's no one to speak to you, to explain to you, you blame our parents didn't do what they were supposed to do, but it had nothing to do. As I'm a woman now and an old woman now, I realized my parents, it wasn't their fault. This was a system that was set up by successive governments because they didn't want us as black people in the country. At the end of the day, that is the bottom line. And they were doing whatever they wanted to do to try and get us out. And it is still happening. Trying to explain yourself, even with a lawyer. It is still happening, right? So,
and you, you initially made an application to the scheme, which was rejected, and then later you got help from Van Ferguson, who was somewhere around.
Exactly.
So the he's behind a pillar. How did having the representation change how you felt engaging with the scheme.
Okay, I thank God for Van first. I really truly thank God for him because he became a buffer. He became someone that he knows the law, he can deal with it. But then again, the type of person I realize I want to know what's going on. So I'm questioning Van as to, and I'm reading the information that's coming back. I never knew anything about subject access. I never knew anything about, he was methodical and thorough, right? In the sense of, I look at him as my son, because my children are older than him, so I told him he could be one of my kids. But the patience that he has had, and he was able to show us we needed to get documentation to prove that we had a house. We needed to get, now you're down on the register in East Ham, yeah? 136 Charlie Monroe, that's where we live. As I said, the information from the DWP, he was able to do that. Information from the Home Office, information from the Army, to prove that we existed, because according to the Home Office, we don't exist. We never existed, not until 2018. Okay? So having a knowledgeable white man representing, I'm giving it to you as it is, because it is as it is. You see my color, and from the time they see you or they hear you, they know it's for Caribbean people, so they don't take you on. And that's how I feel, that's how I felt, and that's how I continue to feel, right? So having someone legally knowledgeable to be able to stand and tell them, hey, this is not correct, that is not correct, the law back in and now I start to read law. Back in 1985, when you leave the country, you automatically lost your status. It had nothing to do with no 2-year law, right? As soon as you get on a plane, you lost your status. That was law. And when you come back to the country, if you go away for 2 weeks or whatever, then your status is reinstated. So learning all of these things made me realize these people are having a laugh. Right? They're taking you for a ride. And I cannot see how you can apologize because you hurt me. And you hurt me. And you turn around and say you're going to compensate me. Well, it does not work. And I'm living proof that it doesn't work. It cannot work. You know why it cannot work? Because up to we're in June, April, in February we had a round table. The Home Secretary was there. Members from the Home Office was there. He asked my lawyer to submit our files. He submitted the files. And when I read the responses in April, it was as if they never read anything on that paper. And this is coming from the lawyer. Has anything changed? The more things change, the more they remain the same. Right? So, if you don't have a lawyer, you
Thank you, Joe.
And Trisha, what you've just said sort of feeds into this about the difficulties that people face in getting their evidence, and one of the strongest reasons that we found, not just for the witness statements, but also all the evidence that they need to get, is one of the strongest reasons why they need legal help rather than any other kind of help. The scheme requires evidence. The evidence, firstly, that you did have the right to be in the UK at the material time. Secondly, that you couldn't prove that you had that right. And thirdly, that you had some loss because you couldn't prove it. So you need all of those things lined up in place. And often that related to applications for jobs, for social security payments, for housing assistance. or attempts to arrive at the airport. But things that happened many, many years ago, even if they were recorded in the first place, you didn't have the evidence of that. And the scheme guidance says, don't worry, we'll get the evidence for you. I mean, that came across so strongly, that's even one of the chapter titles. And so I wanted to come to you, Marcel. You had put together a huge amount of evidence yourself, but nevertheless you got a very low offer of compensation. And so I wanted to ask you a bit about what was why was it difficult to get the evidence that you needed, and what changed when Van came on board?
Sure. Well, I just want to say thank you for giving me the opportunity to give my opinion here. And this isn't my job to make speeches like this or talk as articulate as the lady just did off the top of her head. I have some notes here, so I'm just going to read through these notes. So basically, at every stage of the compensation process, from the initial rejection of the £10,000 preliminary award to the first final offer, the Tier 1 review, the Tier 1 re-review, and the Tier 2 review, it has been extremely difficult. Now, having exhausted the entire scheme and awaiting a response following a review by the Parliamentary Ombudsman and possibly heading toward civil litigation, the burden of proof has only continued to grow heavier at each step. Despite providing direct evidence that far exceeded the balance of probabilities, the compensation scheme consistently ignored it, partially or entirely. Especially when I was representing myself without legal support, I was simply not taken seriously. It was very difficult to get the evidence I needed, as I kept on being asked by my caseworker to provide even more evidence in the form of a letter from my previous employers, my GP, and witness statements from my family and friends. I had to contact numerous past employers with subject access requests in order to satisfy the burden of proof for an actual earnings award for Annex D, loss of access to employment. And because my GP's initial medical evidence was ignored for Annex H, impact on life, and only after reading an online article in The Guardian, I realised I had to spend £1,500 from my preliminary compensation to get a psychiatric report, an expense that was never reimbursed. Despite 5 years of providing direct evidence, my case was only taken seriously once I had legal support from who I call Van the Man, Ferguson, who's behind that pillar, from Southwark Law Centre, and that was after being referred to him by supervising solicitor Anna Steiner from University of Westminster Law Clinic. And since the Tier 1 review, Van Ferguson has successfully challenged each decision, helping to increase my compensation and ease the process. Though after 5 years, it has been emotionally exhausting, not just for me, but probably for Van too. And in my view, it's deeply unfair that individuals who seek to harm British society can access legal aid, while victims of the Windrush Scandal, who came to rebuild the country, contributed through work and taxes, and fully integrated, are first denied their rights and then denied the legal support needed to seek fair compensation. Now, I believe my case is very important, as it shows that even when extensive direct evidence clearly meets the balance of probabilities, and even when it outweighs it by far, it can still be partly or entirely ignored. Now, if that's the outcome for someone with legal support, what chance does a claimant have who only has their word and no access to legal aid? Would the evidence I provided still be ignored if it was a matter of civil litigation in the courts? I think that is the question. Like many others, I believe it's time for the Windrush compensation scheme to be handed over to an independent body that can operate impartially and free from conflicts of interest, instead of continuing to wrong the rights of many.
you want.
Eligibility. Perhaps the first question you look at when looking to see whether a compensation scheme is accessible is you look at how simple it is to determine whether someone is eligible or not. Here, it depends on the immigration status of the applicant. Now, a potential applicant, especially if they're not going to have legal representation, should be able to look at the scheme, look at their own status and their own circumstances and understand whether they're eligible or not. But what immigration status a person holds can be very complex. It can change over time, it can change with changes in the law, and it can change with changes in that individual's circumstances. New legislation, which comes along pretty frequently in the immigration sphere, creates new forms of leave, and they're not always aligned. Lack of clarity about status and the entitlement to status was, after all, the background of the entire Home Office scandal. These questions are often ones which trouble the courts, so it's no surprise at all that we found that they also troubled claimants. Often we found that claimants were not actually aware of the precise and technical basis of their leave to remain. They knew they had leave, but they couldn't have pointed you to the provisions which provided for it. And that can require detailed examination of the immigration rules, which, as I say, change over time. And of course, individuals may at different times have been entitled to more than one type of status. And we saw examples of Home Office or border staff attributing the wrong status to individuals as they entered the country. In one case, we looked at a case for a girl called Patricia. She was refused compensation because the compensation scheme concluded that she wasn't lawfully resident in the UK at the time she suffered the damage. But her right of abode did make her eligible under the scheme's own rules. But it was only detailed examination of those rules once a lawyer became involved on her behalf that showed that they'd misinterpreted the rules. At first reading, the decision she'd received seemed plausible, but it was entirely wrong. A layperson, a claimant acting for themselves, was very unlikely ever to be able to spot that legal error. Frank, you've got a lot of experience of looking at these cases. What kind of eligibility issues have you seen come up?
Thank you. The scheme is really very complex, and I think it's quite unfair to expect that a layperson would be able to understand and navigate through the scheme. As Tim has said, eligibility is one of the fast stumbling blocks, and we see many instances where this happens. Common eligibility issues in the Windrush compensation scheme tend to be proving continuous residence. Many applicants struggle to prove they've lived in the UK continuously since a certain date, especially if they've lacked formal documentation. Now, if you have a case worker helping you, this case worker, or for that matter your lawyer, may help you compile alternative evidence, such as school records, medical appointment, or witness statements. One thing to remember is that individuals are unfairly being asked to prove something that happened in the past when they had no knowledge that that something might become actionable. If I've got a crystal ball that tells me what is happening today might result in an action in 10 years' time, I'll compile all the evidence. I'll build myself a warehouse and keep everything clean, but that is not the case. We also see that establishing right of abode or settled status is another eligibility issue. Some applicants, again, don't have any immigration documentation, despite living in the UK lawfully for decades. I recently represented someone who had been here lawfully since the age of 6 years old, was taken into care, and then the documentary evidence burned. She had no way of showing that she has been here for all that time. Luckily enough, we managed to find alternative ways again to establish that she had settled status. Also, legal advice is often required to reconstruct the immigration history of the person and demonstrate lawful residence. You also have issues with eligibility for specific losses under the scheme. Even if the person can show that in terms of immigration they are eligible for the scheme, you still have to establish a causation between what you say happened and to show that the Home Office was the perpetrator. And again, this requires detailed supporting documentation. You've got citizenship and nationality confusion. Many applicants are unclear about the status due to change in British nationality laws. I have had clients whereby half of the family was born before 1991. It's away into British citizenship, and the other half wasn't. Without establishing what is the status of the mother or the father, it becomes difficult. And I don't expect a layperson to be able to know or understand this kind of nuances. So this is all to say that legal interpretation is often needed to confirm eligibility. You've got delays and you've got incomplete records. Now, the next question to that would be, can these eligibility issues be addressed without an immigration lawyer? My view is that we live in a society that is becoming more and more and more technical. Anything to which you have access to is underpinned by law. Why do I expect no disrespect to my neighbor, but why do I expect my neighbor to understand the law in order to be able to get his entitlement? This is why the likes of us exist. So, supporting applicants in gathering documentation, helping applicants to fill out claim forms, assisting with drafting statements, tracking correspondence with the Home Office, being that channel of communication with the Home Office, analyzing complex immigration history and status under historical laws, interpreting legal definition around nationality and right of abode, appealing or challenging compensation decisions, as well as advising on both the immigration application and applying, and calculating compensation in complex or disputed cases. So there is a range of eligibility issues and a range of things where it is not important, vital, crucial, and almost criminal not to allow the person to have legal representation.
And I mean, I think you've both talked really eloquently about the next issue we were going to come to, which is about that sort of buffer, the lawyer being that buffer between you and the Home Office. And some of the experience we were told about included kind of being called out of the blue, you know, just repeated phone calls asking for things you'd already submitted. And so that was one of the really, really important things that came up. I'm going to skip over that a little bit because we're running very short of time, because you guys have been so brilliant. But I wanted to just ask you, Frank, about some of the reasons why the group of people that we described as cohort 2, why they were not able to make an application in their own right, and whether there's any way other than a lawyer that those people could have made a claim for compensation.
Thank you, Jill. Well, cohort 2 refers to a group of Windrush compensation scheme applicants. We include people with serious physical. That's okay. Now I feel like a rock star. Cohort 2 refers to a group of individuals within the Windrush compensation scheme. We include people with serious physical or mental health conditions, dementia, or those who are made homeless. Now, those individuals often had legal support from the outset, as it would have been impossible for them to navigate the system without that kind of assistance. Why would it not be possible for those individuals to make their applications without a lawyer? The complexity of the application process. I'm a lawyer. I had to learn the process. It didn't come into my head by osmosis. Despite my training, I needed to understand the process. I needed to know how this guidance works in relation to my client's particular circumstances. The process requires detailed timelines, legal explanations, and proof of specific harm. For those with cognitive impairments, for example, or low literacy, this is simply not navigable without the assistance of a lawyer. You've got a lack of access to personal records. Not everybody knows that they can make an application for disclosure from different government departments in order to piece back together what happened in their lives. You have mental health and cognitive barriers. Some individuals have impairment, which makes it difficult for them to engage with the process. You've got communication barriers. You've got individuals who have low levels of English, for whom it is also very difficult to engage with the process. And above all, you are being asked to communicate, deal directly with the organization that has consistently refused to hear you. What makes you believe that that organization is going to be any more inclined now to listen to what you've got to say? So we like to believe that if you have that barrier, if you have, I always tell the people I represent, once I'm in your corner, I am your lightning rod. I'll take what comes, I will take your worries. Once we look after you, you park your worries with us. This is a cohort that's been deeply, deeply traumatized. Individuals were walking in the middle of the night and found themselves suddenly in detention centers, being told that we are going to fly you back to a country where you haven't been for the past 50 years tomorrow. And I think it's actually quite commendable that some individuals did try to engage with the system, but they shouldn't have to. And again, the only way this can change is by recognizing the contribution that legal representation makes to righting the wrongs that we are made against that particular group of individuals. Because at the moment, for me personally, the old compensation scheme is meant to also be an apology, but it's the kind of apology that comes a little bit like, I am sorry to hear that you feel that way. Thank you.
Picking up some of what Frank said about the rules and the way that law and rules work don't appear in lawyers' minds by osmosis. The more complex the rules, the greater the need for a lawyer. Right from the start of the scheme, the Home Office has always insisted that the rules were so simple that nobody would need a lawyer in order to apply. But they clearly failed, and our research in this report shows that they failed. The primary claimant form under the Windrush compensation scheme runs to 44 pages. Even claimants who we examined in the research who had a university education, like Mina, found the form confusing and overwhelming. But in order to access the scheme, it's not just the form that you need to understand. You need to understand the rules relating to the application and the rules relating to how the person examining your application is going to judge it. What rules are they applying when deciding whether you are going to be awarded compensation? The guidance for claimants runs to 30 pages. So the form's at 44, the claimant guidance is at 30. And that's undergone numerous iterations, the last being an update in November of 2024. But even that guidance, the claimant guidance, doesn't indicate the rules which the caseworkers are going to apply when they make the decisions. And it doesn't point to the rules of the scheme or to the caseworker guidance as sources of additional information that a claimant might look at. So in addition to damaging the quality of an application which a claimant is able to put in for themselves, it also means that once the decision is made, a claimant cannot look at that decision and effectively assess whether the offer they've received is in line with the rules, whether their application has been judged correctly, and whether the calculations leading to the figure at the end of it have been appropriate. If one wants to understand the scheme sufficiently, you can effectively engage with it as a claimant. Then the current rules are another 50 pages. They were last updated in October of 2023. The caseworker guidance, which as of November of last year had gone through 18 iterations, runs to 105 pages. So we're well over 200 pages of documentation to get your head around before you can engage with the scheme effectively. And in several cases that we examined, the submissions of lawyers had to be focused on the failure of the compensation scheme caseworkers to accurately apply their own rules and guidance. The Home Office sets the rules for this scheme. They've insisted upon doing so, and they also apply them. There's no appeal to an independent tribunal. But they do have to comply with the essential public duties which affect how all decisions are taken. But these standards and the relevance of them are not well understood by the claimants that we examined, or indeed by the general public. And so individuals need the assistance of lawyers to identify where the errors have been made in the judgments on their claims and to know how to challenge them. Okay.
Thank you, Tim. Just so to very quickly summarise the conclusion of the report, it was very clear from the files that we reviewed that people, as the title suggests, need legal help, and specifically legal help. We absolutely favour the decision that's been made to offer advocacy support, absolutely, but that's not a substitute for legal assistance, for funded legal assistance. You've heard Marcel talk about how he paid £1,500 from his interim payment to get the psychiatric report for himself, which the Home Office never refunded. So a funded legal assistance scheme needs to fund the obtaining of that advice that the Home Office requires in order to make its decision. If they want that evidence, they have to pay for it. We found, we've covered really what we think are the most important things that a lawyer offers that simply can't be offered by any other form of support, and that make it absolutely essential that we do have proper legally funded legal advice. If anybody in the room would like some support to put together a parliamentary question or an early day motion based on what's in the report, we are very, very happy to help you. We really want this to go on and become part of the campaign that I know a lot of people in this room have been long arguing for there to be funded representation in the scheme.
Yes. It's probably worth just putting out some figures for the group just to show the impact of the lawyer. Actually, there was a lot of research which went into this report. It runs to 87 pages. And our conclusions, we think, are very well supported by the evidence. But if you wanted in a nutshell, you could look at the figures which tell the tale of what difference a lawyer has made to the individuals who we've looked at in the scheme. Sandra, her initial decision, an award of £20,000. Ultimately, with the assistance of a lawyer, £170,000. So she was kept out of £150,000 of compensation due to her. Jason, in our report, £10,000 initially, kept fighting for himself, got 55,000. Got a lawyer involved now, 150,000. Emily, £10,000. Once a lawyer became involved, £80,000. Jerome, nothing. He went through, he reviewed initial decisions, he went through tier 1 review. He got a lawyer involved at tier 2 review. £295,000 from zero. Patricia from 0 to £40,000. David, 0, £90,000. Marcia, 0 to £20,000. Michael, 0 to £20,000. And the cohort 2 applicants would not have received any compensation whatsoever because they simply weren't in a position to make a claim without being able to access the pro bono advice that they ultimately were able to access. And those figures we believe speak for themselves, but the report also backs up the reason behind those figures. Why does it make a difference, and what did the lawyer do to make that difference? And it's essential in our view that every claimant to this scheme has the opportunity at least to have properly funded legal advice so that they can get the compensation to which they are entitled.
And thank you so much to our panelists.
We do have a little bit of time to end, but happy to take questions from the room. I think we do have a roving mic somewhere.
I'll grab it.
There's of course on the north side of that room. Okay. I think Anthony had his on. And then we've got Anthony, Dew and Katie all within arm's distance of you.
Oh, Anthony. Over there.
Thank you. Thank you for those presentations, and my heart goes out to the claimants. First, let me say that I've been impacted. I think we've met before, but I haven't made an application because of the trauma that you've talked about. I've just sort of smiled at them when they say, "Why don't you make an application?" Because I've heard all the stories from day one, and I thought better of it. But I wanted to ask, you mentioned that the immigration side of things is very complicated, so I'm not sure why you would recommend removing it from the Home Office, because haven't you then got to go back to the Home Office for decisions around immigration before you could process the claim? That's to do with running the compensation scheme. And the second point is have you spoken to the Home Office at all about your report before you concluded it? Because it seems to me that you had an opportunity there, because a lot of the things that you talked about in it were things that were made, points that were made by the Home Affairs Select Committee, the chair of which was the now Home Secretary. So so what dialogue are you having with the Home Office about this? Thank you.
I think Anthony, I think you've hit the nail on the head. We are not the first people to say that legal assistance is required to effectively access this scheme. What we hope makes the difference here is the ability to prove it. Previously, it's been anecdotal evidence, and going back to first principles of, if you examine the scheme and you look at the complexity, you can form a conclusion that legal assistance is required to access it. What this report, we hope, changes is to demonstrably prove through academic research, being according to a set and defensible methodology of looking at the same cases and looking at the difference it makes and identifying the reasons for that difference. We hope that this is going to be something which could move the needle with the Home Office and should move the needle with the Home Office and push them into providing not just the allowance they've made for advocacy support in the last 9 to 12 months, but also to actually support legal advice on a claim-by-claim basis.
I think we should also say, that Nicola Burgess is in the room, Van is in the room, Frank. These guys have all been having this very long-running dialogue with the scheme leaders, directors, etc., raising all of these points with them, as have many other people. So it's not as if they haven't had the chance to recognise this. Your other questions about whether you just have to go back to the Home Office on the immigration status, not necessarily, because the caseworkers who are deciding this are not immigration lawyers. It's not that they have this immigration expertise. It's, you know, the caseworkers don't have that either, the scheme caseworkers.
Sorry, the caseworkers decide the compensation. They don't decide the immigration status.
No, but you were saying, wasn't your question if you took the scheme out of the Home Office, it would have to go back to the Home Office?
Yeah, but your point you made was that before people access the scheme, there's really complex immigration issues to deal with. So I'm asking, if you take the scheme away from the people who have the expertise to deal with the complex immigration issues, aren't you just creating another layer of bureaucracy?
But the scheme caseworkers don't know about the immigration, so they're still having to go to another department anyway. I don't think it makes a difference.
I think the answer is the Home Office aren't always getting it right about what status a person has. And it's requiring real expertise to go back to them, explain under the law what status a person has, and demonstrating the right under the scheme. So, Jude.
Hi.
Thank you.
Thank you very much. This was so much needed. I was in the room originally when Amber Rudd did low-hanging fruit, and I've been chasing it since then on a advocacy, looking at it from a different point of view. So I am appealing to people in this room, because I've got a lot of knowledge in this room. There's going to be a report put together for the United Nations, and I'm looking for experienced cases who can speak the truth. So anybody in this room who would like to go on the report or in the report, please find me, because unfortunately some of the original Windrush people have passed. You know, Vernon the boxer and Sarah, you know, some of the women that were held in Yarlswood under detention, you know, they've passed. Your stories need to be documented outside of the UK government. So please, you know, all of you, everybody in the room, please come and find me so we can put something together and have the cases documented in another place. Thank you.
Thank you, Jude. Katie.
Thank you. Good afternoon, everybody. Thank you all to everybody who's doing work, and for those who have been impacted by the scandal, willing to share their stories, because it helps us all understand. My question is about what are we going to do with the Home Office with their response of them not having a trace of people that have clearly entered the country, applied to them for applications of naturalisation or registration, and applied to them for further documentation or leave to remain or whatever. If the Home Office are saying that, oh sorry, we don't have a trace of you, then are they not admitting to breaching data protection and GDPR legislation? Because what we should be doing then is reporting them to the ICO and holding them and the ICO accountable to make sure that something is being done to the Home Office. I myself sent in Freedom of Information Act requests to the Home Office to ask if they report themselves to the ICO for losing data, which they should have done according to legislation. I also contacted the ICO with a Freedom of Information Act request asking if they investigated the Home Office. The ICO's response was, any of our investigations, the reports are put online. I then responded to them and said that I've checked your website and I cannot find anything about the reports of the Home Office losing our data from the Windrush Generations, but also many other people's. The last time the Home Office lost data on people, on their immigration files, is just last year, if not this year, but the last time I checked it was just last year. So how are they continuing to lose people's important information? That means they're losing track on who is or isn't an immigrant in this country, and that also poses a risk to the security of the country. And these are the official Home Office, a government organisation, and they are demonstrating to us that they're losing or destroying data, and something needs to be done about it. Thank you very much.
thank you for today and the report as well, in order for us to try and get this scheme taken away from the Home Office. As someone who's been in this from the beginning, I've seen all the different changes, I've seen all the reports that has been compiled and tried to put forward to the government. How are we going to ensure that this report, we do get some sort of action? The government are quite happy to throw money at advocates, but we're not experiencing immigration. I got told off because I filled in someone's status and I got them their passport, but they said they shouldn't have done that. But that's because I want to help the people who had to go through what I had to go to get their status regulated, and then in order for them to get their compensation as well. And it is difficult. And I have to thank the North Kensington Law Centre for assisting me in order for, I was doing it by myself, but I needed that legal jargon in order for it to push as a reality. But I think also, 7 years down the line, what I'm finding is that there's not enough legal firms who understand this whole issue. I don't know what are we going to do in order for them to get the true knowledge of what's going on. I think we did a presentation not too long ago, myself and Van, where we literally had to do like a drama. I played a victim and he paid the home. I did give him pressure, I put him under pressure like I normally do. But this is what we clearly need. We do need, if your report is circulated to all the other legal firms, so they can have a clear understanding of what is happening to the people who's being affected by this whole scandal, because I still class myself as a victim and we need the help. We definitely do. Frank touched on like the homeless people. I'm still getting people who don't even know, they're frightened to come forward. They're losing out on their credits for their pension. And some of them are old age pensioners who don't even know that they can go to Department of Work and Pension and get, you know, so there's so much needed. So what I can ask of you, if you circulate the report to all the other legal firms so that they have a clear understanding, and we are here. We're here. There's so many people that I work alongside here. We're here in order to reality to show you what is going on. We'll do another play, won't we, Van? We'll sit as a drama for you in order for you to see and understand exactly what we are facing. And it is hard, trust me. I get traumatized just listening to people's story, but we do need your help as legal people.
Thank you.
Thank you. My question is for Tim, because he's a partner engagement. And Joe, I know a lot of people in the room who don't know me. I'm Tonika Stephenson from Liverpool Advocates Windrush. I'm curious about something, Tim. Thank you for the report first and foremost, don't let me forget that. It's needed. It's one way, like you said, of evidencing and documenting the challenges. But I'm curious, why are we today, 7 years later, just dealing or addressing the symptoms of the Windrush scandal and not the root causes? A lot of us are junior in the room compared to yourself, Tim. So D-Church and other law firms like yourselves, why not address the root causes? We've mentioned that there are complex immigration rules. We know what sections of said rules are, like which acts. Why not maybe put a motion, as Joe mentioned, or ask and call for Parliament to repeal the sections that have caused the harm? Anthony's asking for a Windrush Act, which makes people British citizens rather than you have to apply because you would have lost your right to vote or your status or whatever the case may be, or you CUKC. Why are we still dealing with the symptoms today and not the root causes? We know the Windrush compensation scheme, for example, which the report targets, is very restricted, very limited. It doesn't offer restitution, it's a compensation scheme. The evidential burden we've heard is really great. Again, the question is, why are we dealing with the symptoms and not the root causes? We've seen the root causes, for example, the post office scandal was a computer glitch. They know now it's a computer glitch, so they've rectified it. Why can't we rectify this historic harm which continues today, affecting 6 generations, if not 5, if my math is correct, you gotta forgive that. But again, why are we still dealing with the symptoms? I chose you, Tim, not the best way possible, because you're a big law firm, but you have the power and the voice in rooms that people like myself don't have as yet, to call on those that make legislation to influence the changes we're all asking and seeking for. Thanks.
I don't think it's a question of you've got to address the symptoms or the causes, but both need to be addressed. And we're doing our best to help support this effort, which we hope will enable a greater number of people to get the compensation to which they're entitled. And that is a major problem. And if it's not addressed, the time is ticking for a great many members of the Windrush generation who have been affected. And so I think it's absolutely right that we're putting the focus on obtaining compensation for the survivors of the scandal. As for the causes, there's a lot of debate to be had that, and you have made excellent points. Ultimately, that's a question where Parliament needs to be persuaded, and government needs to be persuaded. It's not in the gift of private individuals or private law firms to do that. There can be campaigns, and the campaigns have got to do that work in order to address the causes. I know there's lots of people in this room who are working very hard for that.
Thanks, Bishop Desmond Jolly, Chair, Windrush National Organisation. Causational factors are absolutely crucial, but I'm also going to focus on the compensation scheme. Now remember, we're already, and you know this, Tim, we've had conversations, we're dealing with a flawed scheme. So that's the first thing. We're dealing with a flawed scheme that stereotyped our elders as just normal blue-collar manual workers. And that's why these tariffs are quite stingy. Now, we've dealt with cases, myself, my colleague Glenda Caesar, we've brought changes to the compensation scheme. Post-family member payments, for example. Someone who got a job after 3 months, started their own building company, got their own £20,000 a year less. We've managed to have that difference made up by the compensation scheme. It's twofold the problem we have here. We're dealing with a flawed scheme that is not particularly fit for purpose, and then you're dealing with a complex scheme, yes, 44 pages, with repetitive questions. And I now put a line through everything, just do a straightforward witness statement, because I'm from a compensation background, decision maker, investigator and decision maker, and then I just list what we're claiming on the back of it. Now, our largest payout to date is 300,000. Our largest uplift is 125,000 from an original offer. But I will tell you the £300,000, that witness statement was 50 pages long, and it took 6 months to compile. So, when you actually want to really get to the crux of the compensation, you have to list it, you have to then reference it. You guys know this anyway, you're solicitors. I'm from a legal background, but I'm not a solicitor. But the point is that I'm making is that we're dealing with a flawed scheme. So really, that scheme would have to be revamped to be made fit for purpose, because all we're doing is running around, we're just going on around in the carousel. And the thing is, we have to change that. Just briefly on causational factors. I'm not going to call it the Home Office Windrush Scandal. It will always be the Windrush Scandal, which started on the 21st of June 1948, when they tried to turn the ship around out of Tilbury and send everyone to go pick peanuts in Ghana. It was born out of rejection. It was born out of us not being accepted for who we are. The only way when we get true justice is when this society accepts us for who we are. But in the meantime, we have to campaign and battle on, but remember, we're dealing with something that's already flawed. Thanks.
I think nobody in this room is going to disagree that it's a flawed scheme, and we did make a decision to focus quite carefully on the need for legal representation rather than, I'm not going to say just another attack on the scheme, but because those have been to a large extent ignored, we wanted to take that avenue of looking at the legal representation.
That consolidates your argument.
Yeah.
This is why when someone fills a form in on their own,
yeah,
they're filling in a
absolutely.
form that's flawed,
Absolutely.
so they're never going to get
Yeah.
what they deserve. They have to go elsewhere
Yeah.
and seek that professional intervention
Yeah.
to
Yeah.
actually get the right compensation.
And if you think about, you know, how much capacity there is to write a 50-page witness statement pro bono, it's just the perfect illustration. Yeah, exactly. Why people can't do it without funded legal representation.
Can I I'm Pauline Campbell. I'm a pro bono lawyer for the Windrush Justice Charity. And I've got Herbert here, who's come here from Birmingham with his 2 children. And Herbert, I've been trying to get him to say something, but I know he won't, so I will say this. I think that the situation is that, from an educational point of view, since I took on these cases, I am a local authority lawyer. That's my day job, and I do that not 9 to 5, but whenever I can now, because every other waking day is doing Windrush work, and that's what I do. But I also work with city firms to explain, to educate, do everything I can with my counsellors to explain Windrush, because so few people understand the complexities of it. But I don't do it just from the perspective of Windrush. I go back to the beginning of 1919 when race riots were in this country and everything that comes to now. And what's important for Herbert and for every person in this room is, as a lawyer, I have had to be a rock whiler in dealing with these cases. It has detrimentally affected how I see the justice system because of what the victims have gone through. And the best example I can give is 2 weeks ago, I spoke to a wonderful woman, and I raised this a couple of weeks ago, who felt demoralised. And she said, I don't feel comfortable being a part of this. Don't say anything to them that's going to upset them. Please, Pauline, because they may not give me compensation. So I said to her, we're not taking another step until you know you are worth something. You are worth more than anybody in that room, because you have integrity, you are strong, and despite everything you've been through, not one swear word has come out of your mouth, unlike once, in relation to this. And she had to listen. So many victims feel that they don't have or deserve respect because they've been battened and battened and battened down. And as lawyers, even before we start, Glenda, even before she starts, any organisation, even before we start, we have to sit there for 20 minutes, 30 minutes, 40 minutes, letting that individual know you are the most important person within this system and you are worth something. And we're not going to go another step until you know that. Because that's what they bank on, that you're going to back off and you're not going to keep going because you're tired and you're fed up. But we, the vans and all the rest of us, will not stop. Legal representation is crucial, but we need teeth. This report has to have teeth. If it doesn't have teeth, why am I tired? It's got to do something positive, and the MP filter has to be removed, and that is crucial. So I get really passionate, I get really worked up. Thank you for trusting me, Herbert. Thank you for trusting me after everything you've been through, and I respect you to the max. And
I'm being signalled that our time is up. There is cake and wine and lovely things. Thank you so much to everyone for being here. Thank you, Justice. Thank you, Decca. Thank you so much to all of the claimants who are here in this room and who couldn't be here but trusted us, and to the working group of lawyers. You are absolute
well done
superstars.
Well done.